Our case 1CACV 20-0072 entitled Sebestyen versus Sebestyen. Each side would have 20 minutes to present their argument. Appellant, you may save as much time for rebuttal as you wish, but you're responsible for keeping track of the time. Since we're doing this virtually, we have a little clock at the bottom of the screen that my GA will operate to roughly keep track of the time. We're recording the argument in audio and video. So when it's your turn, please identify yourself and your client so that if and when we review the argument, we can keep everybody straight. The argument will be on YouTube in a few days. So if you want to review how you did, you can do that. We've read the briefs and looked at the record move conference case, so we're familiar with the facts and the law and the issues. So when you begin your argument, just start right in with what you want to talk with us about. Counsel, you may begin.
Thank you, Your Honor. I'm James Osborne Pop, and may it please the court. I represent Tom Sebestyen, and he's the appellant in this matter. I'd like to reserve 5 minutes of my time for rebuttal, and I'll try to keep track of that. As Judge Howe says, the court is familiar that the issue is whether the trial court erred in characterizing a benefit from UPS as a community property benefit rather than as separate property benefit based on my client's disability. And the rule we're asking this court to adopt is the basic rule that disability benefits are separate property. And if within the division of property, the court finds grounds to, or can use its discretion to award spousal maintenance if the property division and other factors warrant it.
Counsel, I don't think anyone takes issue with disability payments being separate property. The difficulty for me is whether the payments or the benefits that your client is receiving because he has invoked his pension are disability payments, because they don't look like workers' comp payments to me, because no one's looking at the extent of the disability, the nature of it, or how it affects your client's ability to work. I understand that UPS believes that he's sufficiently, that he has a disability, but I see nothing in the record that says that he can't otherwise work.
Your Honor, I'd have to review the record to see where that testimony was, but it was established that he couldn't work. He receives this payment. He also receives Social Security disability. And in order to qualify for those benefits, I think a showing needs to be made that there is an inability to work, and that is the case here. But the fact I agree with you, Judge, that it doesn't look like workers' compensation. It doesn't look like a private disability policy, but because it's not. But it is a benefit that was acquired through personal injury, and that's the crux of defining separate property or community property. The characterization is defined by acquisition, and normally acquisition is a matter of a timeline. Property prior to marriage or after marriage is separate. Property during the marriage, acquired during the marriage, generally is community property. But when you talk about personal injury benefits, that is the acquisition is based on the injury to the person himself, and therefore it has a separate nature. This rule we know from the Arizona Supreme Court in Zurich, and this court 40 years ago in the case Costco, K-O-S-K-O, followed that rule to determine that the acquisition of the property was in personal injury and therefore separate. So as long as the injury is ongoing, the acquisition is ongoing. When the marriage ends, the disabled spouse has the physical impairment and continues to be unable to earn wages. This court in Costco also said that
counsel, if that's the case, then once the marital community is broken, if the payments that he receives from UPS pursuant to his pension, if they are disability payments, then the wife is never entitled to those payments. I understand the argument that was made below, and I assume you're going to make it now, that at 55, it changes from a disability payment into a retirement payment. But here he has done all that he needs to do to qualify for the pension. At 55, nothing changes because he doesn't need to reapply for the pension. The pension stays the same. So under your analysis, the wife will not be entitled to any payment because it's always it's always a disability payment, and I'm having an issue with that kind of analysis.
Well, Your Honor, your comments suggest that the reference to the position of the other side, that my client somehow took something away from the community or is proposing to do that, when in fact the reverse is happening. There's no question that this benefit was acquired by the separate injury, and if there was never a benefit payable to my client before his age 55, then naturally those benefits have to be classified as disability. And the fact that they are not subject to forfeiture after age 55 doesn't change the acquisition in personal injury. And so,
what's your position? Sorry to interrupt, but what are you saying happens at age 55? I mean, are you saying it remains a payment based solely on his disability? Wife's not entitled to anything post age 55?
Correct. And it's not a matter of entitlement. It's a matter of characterization of property as separate or community.
But how can we say up to age 50, if the day that he stopped working at UPS, you would agree that there was a vested pension benefit, nobody has to do anything more. If he had gone and worked somewhere else, he could just wait until he's age 55 and he could start collecting that pension benefit. Is that correct?
That is correct.
So if that's the case, how can we not say at a minimum that wife has a vested interest in that amount post age 55?
Because there was no deferred benefit before the court. The parties selected this disability benefit back in 2006, 2007, and received payments for 113 months during the community.
But they received them with the understanding that they would continue for the rest of both of their lives.
With the understanding, yes, that the disability benefit would continue. And so the disability continues after age 55. The nature of the benefit being wage replacement before replaces wages to the community, and then replaces the separate wages after the dissolution. If the parties had waited to take a deferred benefit at age 55, there'd be a very different reality. My client would not be disabled. My client would have worked for UPS longer or for some other employer, and likely would still be employed, as age 55 is an early retirement age, not a regular one.
The pension requirement doesn't necessarily mean, if it says you're 100% disabled from being able to work at UPS, that doesn't necessarily preclude employment doing something else, presumably. And it seems, I'm not sure how we can necessarily look to evidence of, let's say there was no other evidence of I've applied for disability benefit. It seems to me that this benefit is simply, we've applied for a pension benefit that was earned by the community. And I'm hard pressed to see how we could, it would turn into a separate benefit, particularly at age 55, where it was clearly there. And if nobody had done anything, it would be available to both of them. And then it makes it harder, sorry to just ramble here, but when they make that election and they take a reduced amount for the rest of both of their lives, it seems like they're both treating it as this is our pension benefit. And it's hard to now say that's a disability benefit.
Well, I think the reverse is true, that they treated it like a disability benefit. My client wasn't working and this brought in money. And I take issue with the phrase you used, Your Honor, when you said that the community earned this. Remember that service during marriage or even payment of premiums by the community doesn't give the community an interest in a disability policy. This court in Costco said that, and the case in Helland, H-E-L-L-A-D-N, excuse me, is the case that deals with a private disability policy. And even though community resources were devoted to it, it didn't create a community asset. Here,
Mr. Osborne-Pop, I'm curious, going back to Judge Catani's question, when they took that election, I noticed that Mr. Herian talked about the fact that having a survivor benefit in and of itself is outside the realm of what a disability policy would look like, because since a disability would be a wage replacement, there wouldn't be necessarily any need or requirement that there be some sort of survivor benefit. So I don't know that if you answered that in trial transcript, I didn't see it, or if it was answered on cross, but what about the idea that this is only a component of something that would be an ERISA plan, having the ability to have a survivor benefit at all from the start?
Well, I think the availability of the survivor benefit is consistent with the acquisition and personal injury, because if there's a recovery, the acquisition and personal injury ends, the recovery from the disability, or if there's a death, the acquisition and personal injury ends, and then the benefit is payable, the survivor benefit is payable to the former spouse. So the retirement benefit, the disability benefit was elected by the parties, and the fact that another option was available at age 55, or that the benefit is no longer subject to forfeiture after age 55, doesn't transmute it into community property. If the court, it's our position that it's a separate property asset, and if that upsets the equitable division of property in a way that the court sees, it can award spousal maintenance, of course, to remedy that. I mean, that's the.
Counsel, in something that is a consequence of your argument is that if it is purely a disability payment, once your client dies, there is no more disability, and the payment should end, and that's contrary to the party's election of a reduced payment in exchange for a survivor benefit. It seems like is kind of having the best of both worlds, that is a disability until I die, and then all of a sudden it becomes a retirement pension benefit. I'm confused about that.
Well, I think because of the acquisition and personal injury as continuing as long as there is a personal injury is why the asset remains separate property.
And would you ever be entitled to disability payments beyond the retirement age? If you're collecting disability, we're saying this is just a disability payment. Doesn't that end at some point when you reach retirement age?
No, I mean, a disability payment, in this case, it's for life.
Well, but I'm saying in the normal, if you're collecting some sort of insurance, unemployment, some disability insurance, is that ever set up to pay you for the rest of your life, or isn't it designed to cover your working years, to cover your disabled? If you have a pension that kicks in, you no longer need a disability payment. And if this pension would have kicked in without his disability, don't you just collect the disability until you need to collect your pension? Isn't that how it would normally be set up?
The disability payment is collected as long as there's a disability. The availability of this deferred option wasn't selected by the parties, and it's not something that transmutes the separate property into a community property asset. Don't forget, when the parties appeared before the court in June 2017, and then the decree came in December 2019, my client wasn't 55, and there was no deferred benefit before the court. There was merely this disability benefit, and the court said, well, because the formula
but it's not just a disability benefit, it's a benefit that's payable until wife dies, if she outlives husband. So
right.
You're saying that part goes away if he dies. It's
No.
Does she not get to collect her pension? How can we categorize it just as a disability payment? If she's getting it, it looks more like a pension benefit.
It has the characteristic of that, but because it's based in his personal injury and because it replaces wages, it is a disability benefit. And at his death, there's no longer the acquisition and personal injury, and she would receive essentially a share of the benefit as a retirement benefit.
But it supersedes the benefit that he had already earned, that she was already going to be entitled to if he had just stopped working and gone to work somewhere else. It doesn't seem like there's any agreement at that point that, well, we're going to now take a disability payment. I'm giving up my right to a pension payment later on. That doesn't seem to be what's in the record as being the transaction.
Well, the transaction was the election of the benefit in 2007, which is based on the personal injury.
And it's a pension election. It's an election to collect a pension. It seems different than just saying we're electing to collect some kind of disability pay.
But it's not a pension, Your Honor, in that it's a disability benefit not available to someone without a disability. The trial court erred by saying the benefit is calculated solely on years of service and focused on the formula, and ignored entirely that there is a disability that prevents my client from working. Well, I see I'm down to about 3 minutes, and I'd like to reserve my time for rebuttal.
Surely. Mr. Berkshire.
Thank you, Judge. May it please the court, Keith Berkshire, attorney for the appellee. I think the distinction here is a distinction that was made in Villanasor, which was the disability is simply a triggering event that causes the immediate vesting of the pension. And when you look at Luna and Villanasor, the issue in both of these cases, there was a very specific formula based on, again, admittedly based on statute in these cases, but on how the disability portion versus the retirement portion of these pensions were calculated. I mean, it was an exact mathematical formula. And in this case, there's an exact mathematical formula that has nothing to do with the amount of disability, the seriousness of disability, anything related to it in that respect. It is simply years of service, the exact same way that the pension benefit itself is. Why
can't? It seems like I could come up with a formula. Maybe it wouldn't be a legitimate formula, but it seems very easy to calculate the portion of this that is attributable to the disability. It's simply the payments that are received up until age 55. You would not, neither party would get that money. That money would not be payable but for the disability. So why isn't that a pretty simple formula? Everything after 55 was something that is what was earned as a pension, and we got to start collecting, and we collected for 3 however long the period of time is, and that exact amount is attributable solely to the disability. Would you disagree that that amount is not attributable solely to the disability?
I do disagree to the extent, again, this is just a triggering event of vesting. I'd agree that, but for the disability, he wouldn't collect it before 55, with a couple exceptions. If he would have continued to work during the marriage, by the time he would have filed for divorce, he would have had 25 years of service and could have collected it immediately at the time of divorce as well.
But this is only triggered with 100% disability, so that means he can't continue to work for UPS.
Again, correct. But if he would have, again, the pre-55, the only condition is not disability. It's if you would have worked for 25 years, you could have got it pre-55 as well. And I think the big distinction here is calculation itself. The calculation of the amount has nothing to do with the extent of disability, short of your analysis, Judge Catani, that the amount is 100% pre-55 that qualifies as disability. But again, this is, I think in Villanous Soar, the court dealt with it simply by saying this was just a triggering event, but the formula itself has nothing to do with the disability, the amount, the condition, the length, anything like that. It has nothing to do with the disability other than the fact he is disabled. That's what triggers it.
Counsel, in a pamphlet that's in the record about how the pension works, it seems that if you take the pension that is triggered because you have a disability, and you take the survivor option, the payment is a few dollars less or a few percentage points less than if you took the quote regular pension and the 50% survivor payment. Can you explain why there's a small difference?
I can't, Judge. I looked at that. I can't. I mean, these are some sort of formula. There's nothing that I saw that was exact on why that formula was different. I don't understand the difference in between them myself. Typically, by selecting, the big difference is typically just by selecting the survivor benefit, which is what causes the major difference to any pension. But I couldn't tell here why there was a difference. And I would have actually, but that selection, Your Honor, I think actually goes in our favor, that typically if you had the disability with the survivor, it might be higher because there was some additional disability benefit. For example, I think it was Villanous Soar, that they gave this unearned years of service as an additional benefit to the disabled party, because that was the compensation. You basically got grossed up to extra years of service because of your disability. That isn't the case here. So I mean, I guess your question, Judge Howe, the common sense one would be that maybe they think that somebody that was disabled might die sooner, but again, that would go the opposite way, that you think you might give them more money. But I can't explain the difference between those two.
But that doesn't, in your view, that doesn't, there's no, that doesn't mean there's any disability component to the pension payment.
I don't think so. Again, when you look at the other cases, and in both Luna and Villanous Soar, that they had specific formulas. This percentage times this number of years times this amount of money was the disability component. This amount times this many years was the survivor, or was the pension component. There's nothing here. And in fact, Mr. Pop, when he was being cross-examined on this, specifically was asked by my client's trial counsel about, how much of this was related to the back injury. And he says, I don't know. I don't have his records. Okay. How much did UPS calculate it when it provided it? The answer was there's nothing in the record. There's nothing in the plan that said there was anything additional given for the disability, the seriousness of disability, like would be done in workman's comp. You know, you lose a toe versus an arm, you get a different amount of money. So here it is simply, the payment is simply based upon years of service times the number and nothing else, nothing that you were, yeah, I mean, I agree that you could be 100% disabled, but the level of 100% disabled could be, you know, you could be comatose versus disabled to working at UPS would be different. So there's nothing related to the seriousness of the injury in any of this calculation. It was just years of service.
If you get rid of the requirement, the 25-year requirement, because let's say that just has no chance of ever being applicable, and we're just down to you can collect at age 55 if you've got at least 5 years of service, and then it's just going to be years of service times this amount. And the only difference there's only two options. You can wait till age 55, or if you're 100% disabled, you can collect the same amount starting immediately. And that seems to me to be the scenario here, where there's just two possibilities, and that's my struggle. Is it seems pretty intuitive to just say the amount that you're collecting prior to age 55 is solely the result of the disability. You've satisfied all the requirements to start collecting at age 55, and that seems to be clearly a community benefit. But you get to collect this early amount solely because you're disabled. And that would be a community benefit until the community no longer exists. And if it doesn't exist, it seems pretty easy to segregate out those amounts, other than the messiness of they've taken a reduced option and which is admittedly pretty messy.
And I understand that from the record, Your Honor. Again, and the prior cases didn't look at it that, I guess that's simply, and for example, the Florida case that we cite from out of state looked at it again as more as just an accelerated vesting of the community benefit versus a separate payment. They looked at it more as just the community earned this right, which was the 18 years of service, the 18.5 years of service, and it might have acceleratedly vested. I mean, it's the same as if a company, you had some stock options and a company sold before the typical, vesting period of stock. It's just some event that occurred that caused this right, the pension right, to accelerate. It wasn't a separate payable benefit. It was just a condition that occurred during the community that caused the community to have an accelerated vesting of the community's right in the pension. Now, again, it admittedly occurred solely because he was disabled. However, he wasn't paid additional disability. He was simply, the community pension simply accelerated. And I think that's the distinction that needs to be made, is that there's a difference between a separate disability policy, something that most places have, a short-term disability payment or long-term disability payment on top of a pension. This was just...
Isn't that the practical effect of these two provisions, though? You have, if you become 100% disabled, rather than giving you disability payments, you get to collect what you're going to collect in retirement. That seems easy to just simply attribute to it. The only reason you get that is 100% disability. There's no question about that. So it seems pretty easy to at least categorize it that way.
And I'd agree with that, again, to some extent, Your Honor, except for the fact that the method that it's calculated was based solely on community effort. It wasn't based on the injury. And the prior case law on this talks about, in Luna, the court specifically stated the amount of disability payments depends primarily on the existence and extent of the disability. I guess you could simplify and say, well, the extent is 100%, but the calculation is just the accelerated investing. And I do want to point to one of the things, I think it was Judge Bailey asked about the survivor benefit. And I think that is another distinction between a pension and a disability payment. By nature, you wouldn't have a survivor benefit of a disability plan because it compensates one individual. So the idea of both experts testifying on this was talking about how the plan was written. And
Judge, how can you hear all right?
Yes, I can.
Sorry, I was wondering the same. But again, a survivor benefit implies something not specifically related to a disability. You don't see disability plans that have survivor benefits. You see vested rights in retirements, vested pension rights in these. I mean, interestingly enough, this is somewhat being tried to be related to the military type pension, the military type cases. Howell, Merrill, and Mr. Pop and I were both on Merrill, which was the sister case to Howell, where the only reason that those disability payments ended up being separate property was because of federal preemption based on statute that classified them that. But the case law prior to that was that if you took your disability payment, I mean, from this court, the Supreme Court, and so forth, that if you took your disability payment in lieu of the retirement payment, then the court had to indemnify. And the only reason that the indemnification got overturned by the U.S. Supreme Court was because of a federal preemption. But all case law prior to that was that you can't, supersede these rights. And
Counsel, we've talked about pre-55 and post-55. There's really nothing special about the turning of 55. He has his pension now. If he does nothing, he's going to continue to receive the pension until he dies, and he doesn't have to reapply for a regular pension at 55, correct?
Correct. I mean, the concept that the separate property continues past when the community would have unquestionably got it, it doesn't make a lot of sense to me, just because no matter what, I think as Judge Catani said, is if you would have just quit at 18 and a half years of service, he would have got it at age 55, no matter what. And so we're talking about a semi-discrete period here. I mean, looking back at this, the issue is he turned to 55 within a couple months after the decree was entered. So we've got a couple year period here that if you look at the pre-55 as potentially separate property, the court in this case could have easily just called spousal maintenance in the exact same amount, the same as the parties did. If you read the parties' temporary order, the parties actually classified the payment to wife in the amount of half of the, I can't remember if it was exactly half, but I think it was, the pension benefit as spousal maintenance, which the court could have easily just considered. And again, since this is, if you're looking at trying to segregate out the pre-55 amount, we've got a period that ended 3 months after he turned 55, I think 3 months after the decree. So we're talking a very discrete period here that essentially could be looked at as a harmless error because the court.
It's a couple of years total.
It was like 2.5, I think, maybe.
Yeah, 2.5. Wouldn't we want the Superior Court to pass on that first? If we were to agree with you, why wouldn't that be something we would have the Superior Court decide?
For the determination of spousal in that period?
Yeah, to determine if it would have changed. If it was misconstruing how to value the pension.
Now, I understand your desire to remand if that was the issue. But again, I think that the big thing on all the case law here, that when we look at all of, Jurek and these other types of cases and Villanasur and Luna, it's the big issue is that how this was calculated, the calculation method, and that it was based somewhat on the disability. Here, you'd have to just assume that it was 100% based on disability, even though the formula itself is based solely upon years of service. And so in Luna and Villanasur, I think the calculation is somewhat easier from the standpoint is here's the separate portion, here's the community portion. But in those cases where there's some pre-typical retirement age, I mean, those cases had a pre-typical retirement age component, they still had a portion that was community. So our position is that this is just simply a triggering event that led towards an accelerated vesting of a community asset, because the asset itself is clearly solely based on years of service, which was attributable to community. It wasn't based on I lost a leg or both legs or arms or anything else that had a monetary amount like workman's comp would have. It's based solely upon the years of service. And again, I think the Florida case that we cited, I think it was Gaffney, that said the only effect of the disability was that it allowed him to get it 2 years early. And that case was simply the same exact scenario, that it didn't have a difference in the amount. It's the disability was this triggering event to an accelerated vesting.
If UPS make the determination that an employee is sufficiently disabled to trigger the pension, is that a preclusive determination that the person is disabled for other purposes?
No, I don't think so. I think there's even some case law out there on child support that talked about an SSDI qualification isn't a finding for any other court on disability or so forth. I mean, I don't think that there's some. I don't think a private industry can determine whether you're disabled from, and supersede a court's ability to determine that itself. I mean, you could be disabled as a pilot because your eyesight goes bad, or you had diabetes, which wouldn't necessarily disable you from having other employment.
So I think it's the case here that Mr. Sebestyen was disabled because he got workers' comp. The mere fact that UPS deemed him disabled doesn't mean that he would be disabled for other purposes.
And admittedly, Your Honor, I don't remember that in the record, the contesting of whether the disability for other purposes, but I would agree with your premise that the idea that a business declared you disabled. I mean, UPS, if you can't, lift packages, you're potentially disabled from that job. That doesn't mean you can't sit at a desk and potentially make more money. So
sure.
Do you know if UPS ever reevaluated his disability, or whether there was any kind of component to be able to do that? And I'm thinking of, say, he's considered 100% disabled, but then a couple years later, he's not. He's still pre-55, but he chooses to remain, under the pre-55 payments to ice out life from being able to get a community portion of it by keeping it as a disability payment. Do you know if there was any way that UPS went back and reevaluated?
I don't remember any evidence in the record that they ever looked at him again or that he was examined again, Your Honor, but I don't remember that from the record. Okay. There could have been, but I don't remember anything about him being reevaluated. It's not like I think the military that you have to go in every 2 years depending on your disability or something. I don't remember UPS having to do that.
Once he qualifies for the pension, he qualifies for the pension, and UPS doesn't have any need or desire to periodically evaluate the retiree.
I mean, post 55, it would make no sense because there's no difference to the amount. I mean, if he's disabled or not, it transmutes. I mean, the only reason it ever mattered in all the military cases was it was tax-free versus not. But here, I mean, that's another thing. A lot of times disability payments are, because they're personal torts, are not taxable versus compensation for wages, which is taxable. But I can't imagine why they'd reevaluate post. I mean, especially if he's so close to 55, why they would do that. I see my time's up.
Thank you, counsel. Mr. Pop.
Yes, Your Honor. I'd ask the court to consider the case Costco again, because the reason the court found that the benefit was disability there was based purely on state law grounds, and that's an important element that they mentioned in their footnote 1. It's very difficult to compare this situation to the military's benefit or other federal schemes, because that requires a statutory analysis that we simply don't have here. And that's why I keep going back to acquisition, because that's the state law ground under which the benefit determines its character.
Would UPS ever pre-55 reevaluate a person to see whether they're still disabled to entitle them to the pension payments?
They could reevaluate before age 55, and if there was recovery, the disability payments would stop.
Is there a procedure for doing that?
I'm not familiar with that, Your Honor, and I don't know if there was an evaluation post after the initial determination.
Thank you.
And the other point of an inability to do the job at UPS doesn't make it any less a disability, or that it has its origin in personal injury. In that Helen case, the disability policy was one of those own occupation policies that if you're disabled from your occupation, you might be able to do something else, but if you can't, in that case, practice as a physician, then we're going to compensate you. The same thing is here, and that was a separate property benefit, of course, there, because it was tied to the personal injury. And in that case, the doctor retrained and worked in another medical field.
But there wasn't any kind of an option for a spouse for them to take a reduced amount in that situation. That seems very different than when you're making an election and saying, yeah, this is going to be, we're taking a reduced amount, we're both entitled to this. That looks more like a disability payment than a pension payment.
The options available are all the same amount of money. It's just different ways of payment. That's why they reduce if there's going to be a payment to a former spouse or a spouse if there's a death to the disabled person. Did I address your question, Judge?
I think so. I guess it's just in Helen, it's just the doctor is no longer able to do his specialty. There's a payment for that, but it's not set up as this is going to continue for the rest of our lives, and my wife and I can make an election and have it be a reduced amount. So it seems much more like a properly designated separate asset than when we go in and say we want to provide for ourselves in retirement, and this is our pension plan. This is an election we're making.
May I continue, Your Honor?
Sure. Sorry.
That's okay. Yes, in that private disability policy, there were no optional forms of benefit. This employer-based policy did have those options, and the parties took advantage of them. But each system needs to be looked at on its own, and care should be taken when comparing two federal plans or other statutory schemes or a private plan. And it's our position that this is acquired in disability and is my client's separate property. I'll stop there as my time's run out.
Thank you, counsel. We appreciate your arguments today. We'll issue we'll take this matter under advisement and we'll issue a decision in due course. Thank you again. We stand at recess.
Thank you.
Thank you.